The California magazine ban case and the potential for another Freedom Week is now being argued up at the Ninth Circuit en banc level. So let's talk about this. But real quick before you jump in this video, if you think magazine bans are clearly unconstitutional and violate the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to mention that we have an event coming up. It's going to be October 7th through the 8th. It's going to be in San Bernardino at the Route 66 Shooting Sports Park. It's the annual Range Expo. I will be there. Reno May will be there. Mike Glover, a ton of other companies. So if you want to support the 2A cause here in California, if you're in California, please consider coming out. I will leave links down below where you can get more information. It's always a fun time, and I would love to see you guys there. As I mentioned in the intro, in this video, we're going to be breaking down the current arguments which are going on at the Ninth Circuit en banc level, and this is in relation to the California magazine ban case, Duncan v. Bonta. Recently, a Ninth Circuit en banc panel decided to fudge some of their rules and take review of this case right here and now immediately. And now both sides are putting all their efforts into getting the Ninth Circuit en banc panel to side with them on whether or not an emergency stay should be granted. Now, for those not aware, Duncan v. Bonta involves the California possession and purchase ban on so-called large capacity magazines. This law was originally challenged in a district court before Judge Roger T. Benitez, who issued his original ruling which found that this law was a violation of the Second Amendment. This led to what is known as Freedom Week in the state of California, and then after that, the state of California, after they lost that original challenge, they appealed that decision up to the Ninth Circuit. It first went to a 3-judge panel, and on review, a 3-judge panel in the Ninth Circuit reviewed the case and sided with Judge Benitez and also sided with the Second Amendment. They found what Judge Benitez did was correct. Then the case was sent to the Ninth Circuit en banc panel, which is a panel of 10 randomly selected judges in the Ninth Circuit, since the Ninth Circuit is so large, and then also one additional judge, which is always the chief judge. On review, the Ninth Circuit ruled in favor of California. That decision by the en banc panel was then appealed up to the Supreme Court, and it sat at the Supreme Court level, but after the Supreme Court ruled in Bruin, the Supreme Court then decided to grant, vacate, and remand the Duncan case back down to the Ninth Circuit for them to redecide the case in light of the recent Bruin decision. Now, at that time, the Ninth Circuit could have reevaluated the case, but they decided instead to send the case all the way back down to Judge Benitez. Well, on Attorney General Rob Bonta's birthday, Judge Benitez released his decision in Duncan, and ultimately he ruled once again that California's magazine ban is a violation of the Second Amendment, and therefore he issued an order to prevent it from being enforced. Now, in the same order, he also granted a 10-day stay of his order, which meant that it would not go into effect until October 2nd. He issued that stay, and California was given the opportunity to appeal his decision up to the Ninth Circuit and also seek a stay from the Ninth Circuit. And in fact, California did do that. They filed a notice of appeal to the Ninth Circuit, and all expectations was that it was going to go through the traditional process, and it was going to go to a 3-judge panel, likely an emergency panel as well, for review on whether or not a stay should be granted. However, we got a huge curveball in this case. We received an order from the Ninth Circuit en banc panel that they decided to take review of the emergency stay and a review of the decision on their own as a comeback order. So instead of going to the traditional 3-judge panel, it is going directly to the en banc panel. Now, this is both good and bad. One of the silver linings with all this is that now we're going to bypass the 3-judge panel, and likely this case is going to be expedited through the process at least a little bit, and ultimately will probably reach the Supreme Court faster than we thought. The en banc panel claims that under their rules, they can take this case right here and now as a comeback case and rehear it, and in doing that, the en banc panel also issued an extension of the stay, which will now be in place at least until October 10th. The reason the Ninth Circuit en banc panel likely did this is they probably wanted to take this case immediately to prevent any pro 2A opportunities from happening, or any denial of the stay at the 3-judge panel level, or even before an emergency panel. So that's probably why the en banc panel stepped in right here now. Now, when the Ninth Circuit en banc panel sent out the order that they would take the emergency review of this case from the 3-judge panel, we also got some interesting dissents. One of the judges, Judge Van Dyke, had a dissent and pretty much revealed some of the weirdness that goes on at the Ninth Circuit, and essentially just a lot of the corruption that's been going on. And he revealed that this case probably should have been ended and should have not proceeded forward, and this should have ended all the way back in 2020. Judge Van Dyke in his dissent revealed that after the 3-judge panel first issued its opinion in August of 2020, one judge on our court requested Rule 5.4b notice in 3 cases, including this one, but then inadvertently missed the deadlines to timely call the case en banc under our clear rules. That could happen to any judge, he stated. But rather than simply accepting the results dictated by our rules, or even deciding as an entire court to waive our rules, we went in a different direction. In sum, he states, not only is our court treating this case special now, but the process that brought this case en banc in the first place was illegitimate from the start. This demonstrates and perpetuates this court's anti-Second Amendment posture, rewards the weaponization of one-sided collegiality, and damages the internal and external integrity of the court. How are we to uphold the rule of law and reassure the public we are doing so when we disregard our own rules and make questionable decisions like this behind closed doors? So that was a striking revelation, but this case is still going to proceed forward at the en banc panel level, even despite some of the weird rule changes and bending of the rules that happened. This is still going to be reviewed by the same 11 judges who were already selected at the original Duncan panel, who already reviewed Duncan before, who ruled against the Second Amendment before. It's going to be the same panel who's going to review this right here and now, and also this emergency stay. Now, the parties have submitted their briefs to the Ninth Circuit on why they should not grant the emergency stay, halting Judge Benitez's decision, essentially preventing it from going into effect. For those who maybe want another potential Freedom Week, that is exactly the battle that is happening right now. This review of the emergency stay request is going to determine whether or not there is going to be a potential Freedom Week or whether or not Judge Benitez's order will go into effect. Now, I would give you guys my point of view. I don't think that this is going to happen. The likelihood is that, in my eyes, they're just not going to rule in our favor. But right now, CRPA is doing everything that they can to try to make that a reality. So again, go support those organizations that are doing great things. I will leave a link down below to CRPA where you can donate and help their efforts. Now, in support of their emergency stay request, California did make some interesting arguments. They argue that the equitable factors also weigh heavily in favor of a stay. A state suffers irreparable injury whether it is enjoined from enforcing a duly enacted statute, and here the threatened injury is especially grave because of the dangers that large capacity magazines pose to public and officer safety. Plaintiffs acknowledge that the denial of this motion would prompt a sudden and immense flood of these magazines into California. A stay pending appeal would avoid that abrupt change in the status quo while this court resolves the merits of this appeal. So one of the main factors that the state of California has to show to win their stay request is that they will be irreparably harmed. They claim that the flood of standard magazines would cause an influx of crime and danger, and therefore the state and the public will be irreparably harmed. However, to this point, I would argue that we really saw from Freedom Week that millions of magazines were brought into the state of California, were purchased and possessed, but there was zero evidence, and California has presented none, that led to an increase in crime or dangers to the public. Now, California then goes on to argue that magazines are not protected because they're not actually used for self-defense. The state of California argues that plaintiffs also argue that actual usage of a type of arm in self-defense is plainly irrelevant to Bruin's inquiry into whether the arm is in common use for self-defense because actual ownership is the standard. So right here they're hinting at, our side is saying that actual ownership is the standard for common use for lawful purposes like self-defense, but California is arguing for actual use, that these items would only be protected if you actually use them for self-defense or if you actually use them, in shootings. They argue that common ownership is not enough. So right now the parties are battling over whether or not emergency stay should be granted in this case. If it is denied, then the Benitez order goes into effect and there could potentially be a Freedom Week. Now again, in my eyes, I think that's a long shot and I would not hold my breath for that type of situation. We know this 11-judge panel is not favorable on this topic. They've already ruled against us in this Duncan case before. And the fact that they decided to jump into this case early and take the review of this, bypassing the 3-judge panel, would signal to me that they do not want a favorable 2A decision. They want to control this case to prevent a situation like that from happening. But this is the battle that's going on right now. Our eyes are essentially going to be on October 10th to see, how this happens or how this plays out. They have to issue the decision before then because their administrative stay only goes out to October 10th. And if it goes beyond that, then potentially, the Benitez order would go into effect anyways. So if we get any more information, if anything else develops, of course, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help us fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.